Good afternoon, Your Honors, distinguished guests, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, it's a great pleasure to welcome you to today's public lecture entitled Law Beyond Borders, Courts, Constitution, and Rule of Law in a Canadian Experience, hosted by the Constitutional Court of the Republic of Indonesia. We are delighted to have you with us in this afternoon, both in person and online, for a program that brings together judicial perspective from Indonesia and Canada in a spirit of dialogue, learning, and cooperation. So at the Zoom platform, there are 500 participants joining this event, consists of official staff of the Constitutional Court of Republic Indonesia and law students from universities in Jakarta that participate in internship program in the Constitutional Court, and the representative from 69 universities in Indonesia and constitutional villages that cooperate with the Constitutional Court of Republic of Indonesia. Ladies and gentlemen, it's a truly honor for us to welcome our distinguished speakers from the Supreme Court of Canada, whose presence this afternoon reflects the strong spirits of judicial cooperation between our two countries. We are especially honored by the presence of the Right Honorable the Richard Wagner, Chief Justice of the Supreme Court of Canada. Good afternoon, sir. The Honorable Malcolm Rowe, Justice of the Supreme Court of Canada. The Honorable Mary T. Moreau, Justice of the Supreme Court of Canada, and also His Excellency Jess Dutton, the Ambassador of the Canada to Indonesia. We are sincerely appreciate your willingness to share insight and experience on the role of court in safeguarding the Constitution and the rule of law. Ladies and gentlemen, without further ado, I would like to invite Mr. Pan Muhammad Faiz Kusuma Wijaya, the Head of Bureau of Public Relations and Protocol of the Constitutional Court of Republic of Indonesia, to lead us into the main session and moderate today's discussion. Mr. Faiz, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen, all the participants who attend this event through online or physically in this room. Welcome to the Law Beyond Borders program organized by the Indonesian Constitutional Court with special theme Court, Constitution, and the Rule of Law, the Canadian Experience. On behalf of the Indonesian Constitutional Court, I would like to thank all participants for joining us today, and to our distinguished speaker from the Supreme Court of Canada. Today, we have the privilege for exploring how courts, particularly the Supreme Court of Canada, play a central role in upholding the rule of law amidst an increasingly complex global landscape. We will hear the first-hand reflection and experience from judges directly involved in constitutional adjudication and upholding judicial independence. But first, allow me to briefly introduce our honorable speakers. The first speaker, the Right Honorable Chief Justice Richard Wagner of the Supreme Court of Canada. He has served as Chief Justice of Canada since 18 December 2017 and as a Justice of the Supreme Court of Canada since 5 October 2012. He is known for promoting transparency and access to justice through initiatives such as the case in brief judgment summaries, the annual year in review report, Supreme Court sittings held outside Ottawa, and his advocacy for legal aid funding, pro bono work, and the modernizations of the judiciary. And the second speaker, we have Honorable Justice Malcolm Rowe, Justice of the Supreme Court of Canada. He has served as a Justice of the Supreme Court of Canada since 28 October 2016. His career spans public service and international practice. He was appointed a judge of the Supreme Court of Newfoundland and Labrador in 1999, a judge of the Court of Appeal 2001, and subsequently a justice of the Supreme Court of Canada in 2016. And last but not least, Honorable Justice Mary T. Moreau, Justice of the Supreme Court of Canada. She has served as a Justice of the Supreme Court of Canada since 6 November 2023, the newest one. Before we had a discussion, and she said a baby one. She was appointed to the Court of King Bench of Alberta in 1994, later serving as Chief Justice of the Court in 2017, and was active in judicial education as well. And another one, she served as a member of the Canadian Judicial Council before her appointment as a Justice of the Supreme Court of Canada. We are deeply grateful to Your Honor for taking the time to share your insight with us. And our session will run for approximately 1 hour. It is not an Indonesian model because usually it can run out 2 or 3 hours, but this is very short one. So please bearing in mind. First, we will have presentation from our speaker, and this will be followed by question and answer, a short one, and finally a short closing. For the presentation segment, each speaker will have only 10 to 12 or 15 minutes, very short. And after all the presentations have been delivered, we will have more Q&A. And without further ado, I would like to also inform there is a participant following our sessions. We have a quota, unfortunately, 500 participants through online, and they are still queuing. So if there is someone go out from the Zoom, then everyone will also go inside. So 500, that's amazing for today's event. So without further ado, we will begin our first session. It is my honor to invite Honorable Justice Mary Moreau to deliver her presentations on Canadian judicial system, appeal mechanism, and selected challenges. Your Honor, you may begin.
Selamat siang. That's a good start. Thank you so much for inviting us here. And it is a real thrill to be involved with not only this live audience, but a video audience all across this lovely country. So thank you for this privilege. I'm here to set the table for the other speakers because my talk today will be pretty basic, and some of you might even know a few of the things that I'm going to be talking about. But I think it's important to get the basics down, and then you will find that we will layer onto the basics with the other discussions. So let's start with a geography lesson. Canada is the second largest country in the world after Russia, before US and China. But its population is, compared to Indonesia, a lot smaller, 40.5 million people approximately in my country. and I understand that there are 42 million in Jakarta alone. So we have a lot of room to move in Canada. It's large and it accommodates many. It has 10 provinces and 3 northern territories that are administered by the federal government. And so we'll go on to talk about the court system in Canada. And I'd like to start with the pyramid. There it is. So we have 3 levels of court, and you probably can't see the writing too well, so I will brief you on it. At the base of the pyramid, the largest section, are the trial courts of our country. Provincial courts in our different provinces and territorial courts that deal with trials, civil, criminal, commercial matters, and then, and so you would have provincial courts, but we have our military courts that are federally appointed. We have federal court that deals with federal laws such as immigration, customs, and we have the Tax Court of Canada. So they're at the base. But those who are not particularly pleased with what happens at that court level can, in certain restricted circumstances, appeal to the next level, which is the higher level of court, and it means that they can go to a provincial or territorial court of appeal that sit in panels of 3, whereas the trial court in Canada sits as judge-alone trial courts. In the case of criminal charges that are more serious, judges with a jury of 12 members. And they are civilians, like you. And they decide the guilt or innocence of an accused person if the charge is a serious one. From military court, you see there's a court-martial court of appeal, and from the federal court and tax court, federal court of appeal. And then finally, certainly not last but not least, is the Apex Court of Canada, which is the Supreme Court, and my colleagues and myself, we are members of that court. And obviously, that's where it stops. The decisions of our court cannot be appealed any further. There is a process by which we hear cases because we will not hear just any case. We generally will grant leave to appeal in civil cases and in criminal cases that involve issues of national importance that will have an impact on Canada as a whole, for example, and also where the different courts of appeal at the second level that you see disagree on issues of law, so that there is not a consistent principle being developed, and so they asked the Apex Court to sort it out for them. And so that's one of the areas that we deal with. We have other cases where in the Court of Appeal, I mentioned a panel of 3, there may be one judge on that panel who disagrees with the result. And if that's the case, there is an automatic right of appeal to our court. We sit as panels of 9 because we're a court of 9. The Chief Justice will speak to you about the diversity within our court, so I'll leave that to him. We sit as panels of 5, 7, but most frequently all 9 of us. So we have, I think, the next slide. We've covered applications for leave, and this is our courthouse in Ottawa. And it's a beautiful environment. I had the pleasure of appearing as counsel in that court, and that would be where the main stand is, and the lawyer is speaking to the court, and it was a lovely experience to be on the other side of it. We also at the court have an interesting function, and that is what we call a reference. So provincial governments and federal government can ask the court for its opinion on the constitutionality of a federal law or a provincial law. And so it's very helpful to the legislative branch of government and the executive branch to hear from the court as to whether there are constitutional problems with the law. It gives them an opportunity to fix it, to amend the law in order to render it constitutional. So that's another job that we have. We're not as busy with those kinds of cases, but certainly they are of assistance to the public. One of the challenges, as I wrap up my short speech for our court has come in recent years with self-represented litigants. These are individuals who, for the most part, cannot afford to pay for legal counsel to argue their case for them. And so they come to all levels of court that you've seen in the pyramid in great numbers. And because they have no legal training or background, it becomes a bit of a clog on the system. And so we need to find ways to address how to teach them how to present their cases and to do so efficiently. And so what you see there is a handbook that has been developed by the Canadian Judicial Council, which is the council of all federal chief justices in Canada, led by our Chief Justice Wagner. It's a wonderful handbook in family law, criminal law, civil law that breaks down from A to Z what steps need to be taken in order to bring a case successfully to conclusion. A little bit about AI. That's another challenge. We are all aware that AI tends on occasion to spread misinformation and disinformation in various areas, and the courts are not free from that problem. And so we have developed some guidelines for lawyers who rely on case authorities, which decisions by higher courts, for example, in Canada, which are authoritative in certain areas of the law. If they're relying on them, they have to check to make sure they really exist. And I say that very deliberately because we have had occasions where they have been fictitious decisions of courts that have been relied on, and that can be very difficult, and obviously it's something that we need to be very wary of. So I'm going to close my presentation with the final slide, which is reminding me of my home province of Alberta. That's what it looks like, and you're all welcome to join me there. Thank you very much for your attention.
Thank you, Joanna, for sharing such valuable insight. And the last slide. Hopefully someday some of us will go to the village of our honor. For the second sessions, we will have Honorable Justice Malcolm Rowe to share a presentation on the historical description of the Constitution of Canada. Your Honor, please.
I would like to indicate, as did my colleague, how deeply honored we have been to be invited and to be received by such a prestigious and important court as the Constitutional Court of the Republic of Indonesia. This morning it was a great pleasure and very instructive to meet with several judges of that court, one of whom was the Honorable Justice Kuntar Hazam. And when he spoke, he placed in historical context the development of the constitutional law of the Republic of Indonesia. And it reinforced to me the importance of understanding constitutional arrangements within their historical context. And that's especially true for Canada. People tend to think of Canada as a new country. It's actually somewhat older than you think. I'm going to start a long ways back, but I'm going to move things along. The Europeans first came to Canada 500 years ago. But of course, there were nations, there were societies that existed before then. They were the first peoples of Canada. They were what are called now the First Nations, what used to be referred to usually as Indians. And then there are the Inuit, who used to be referred to as Eskimos. These were, of course, autonomous societies who governed themselves by their own laws, customs, and practices that were unique to each group, and there was great diversity. Now, that was the age of empire and exploration. And of course, the first European explorer to encounter Canada was an Englishman, John Cabot, in 1497. He intended to go to the Spice Islands. As a matter of fact, he was trying to get to Indonesia. But in fact, there was something in between. It was North America. But that was the initial contact. The settlement by Europeans commenced in 1608, and it was actually by France and the establishment of New France, principally to conduct the fur trade. And that continued to be the mainstay of a very small presence in the eastern part of what is now Canada. It was, as I said, the age of empire, and the two relevant empires were the French and the British. And of course, they fought it out. And in the end, in 1763, the British seized New France, and it was incorporated into the British Empire. Shortly thereafter, in 1776, the 13 colonies along the eastern coast of North America rebelled against the British Crown, and the United States of America was formed. However, the colonies in the northern part of North America repulsed the Americans who invaded us, fortunately. And so after 1783 and the establishment of the United States, there was a division. And so there was the United States in the southern part of North America, and to the north was what would be referred to as British North America. And this continued for about 100 years again, from 1783 to 1867. During the period of British North America, there were colonial governments which were established throughout the eastern part of the continent and then gradually into the western part of the continent. Very small populations. They were subordinate to the British government. But what was interesting is that they were given a high degree of local autonomy. In fact, for most purposes, they governed themselves. And there were institutions which were established in each of these small colonies, which were very similar in nature to the governmental institutions in the United Kingdom. Things changed in 1867, and now we're getting into the period where there is something which is called Canada as we recognize it today. Because in 1867, the colonies, these small colonies, were brought together into a larger new country called Canada. And on that occasion, the creation of Canada is very similar in a parallel way to the creation of Australia in 1901. So what you know about Australia in terms of how it's organized and how it functions, in many, many ways you can just transpose that into how Canada operates. So the system of government, which as I said was copied from the United Kingdom, was carried forward in Canada, and frankly, it continues to operate today. So what you have is a system of government on a day-to-day basis, which involves an unwritten constitution, which has functioned in what is now Canada for literally almost 200 years. And thus I say there's a certain historical perspective is of assistance. But in terms of Canada itself, which was created, as I said, in 1867, what was created was a federation. There was a national government and there were provincial governments. And under the Constitution Act of 1867, the national government was given authority for, broadly speaking, national matters, trade and commerce, banking, and the like. The provinces were given authority in local matters. And the provinces are not subordinate units to the national government. The provinces are sovereign within their own jurisdiction. Canada is not a unitary state, it is a federation. And so the division between the federal competence, the federal jurisdiction and provincial jurisdiction established in 1867, that division of authority continues to exist to this day and has not been fundamentally changed. One thing that has changed, which is of significance, is the authority over things like education, the authority over health, the authority over social services, which was a very small authority in 1867, has become quite prominent today as the role of the state in the lives of its citizens has greatly increased. And all of this authority is vested in the provinces. So the provinces are quite, the governments of the provinces are quite significant in the government of the country. I'm going to go back briefly to discussing the situation of First Peoples, because it's a matter of great importance for Canadian society, and it's a matter of great importance for Canadian identity. The population at present of First Peoples, in what used to be called Indians and Eskimos, First Nations and Inuit, is about 500,000 out of a population of Canada of about 40 million. But as I said, it's important to us in terms of who we are as Canadians. There were quite distinct periods from the earliest contact up to about the 18th century. There was a pattern of trading and an alliance with First Peoples. And of course the trade largely related to the fur trade, because it's a northern country. The 19th century was what happened during the 19th century was that the land was cleared, heading west, great forests were cut down, and agriculture was developed, a lot of small farms. And tragically, what happened was the indigenous peoples were pushed off their land and were subject to somewhat cruel treatment, and somewhat to the shame of our country. They were left their autonomy was deeply undermined. Now, from 1975 onwards, so for about 50 years, starting about 50 years ago, there was a very significant change which began in Canada to try to reconcile these First Nations and restore to them a degree of autonomy and a role of respect within Canada. It's very much a work in progress, and it involves entering modern treaty relationships with them. I just note at the bottom of the slide, as we'll come to in a second, the Constitution Act 1982 now gives constitutional protection to the rights of Indigenous peoples. All right, I'm going to go back in time to the situation of Canada overall. 1867, part of the British Empire, semi-autonomous, but foreign relations and military matters were left to the imperial government in the United Kingdom. That came to an end effectively at the end of the First World War in 1919, and in a very formal and legal sense, it was completely brought to an end in 1931. So roughly for 1 century, Canada has been a fully independent country in all legal respects. The next development of a constitutional nature, which is highly, highly significant, was the Constitution Act 1982. There were several things that were done. The first one is there were procedures which were established for the amendment of the Constitution. Oddly enough, there had been no means to do so before then, but there were arrangements put in place which essentially involved the requirement for the federal government and the provinces, or at least a majority of the provinces, to agree to any constitutional amendment. So neither party, neither the provinces nor the federal government can act without the agreement of the other to amend the Constitution. The second point, which is again of great significance, is the Canadian Charter of Rights and Freedoms. And this deals with similar rights to those in Indonesia, things like liberty of religion, of expression, freedom of association and assembly, the political rights to vote and hold public office, legal rights in terms of arrest, search and seizure, having a trial before an impartial tribunal and the like, and equality rights, which means that it's not permitted to have discrimination in law or in practice based on race, religion, ethnicity, sex, and the like. And finally, one thing that is unique to Canada, because Canada is a bilingual country, this Quebec, New France, there was the link to France itself was broken in 1763, but the French culture and the French Francophone society in Quebec and throughout other parts of the country has been maintained and is vibrant, and is the language rights, French and English language rights, are protected also. It's an important part of the Charter of Rights and Freedoms. And there was protection as to the rights of Indigenous peoples, and frankly there was an enhanced role for the courts, because what was granted in the Constitution Act 1982 was authority which can be broadly put under two headings. One is the authority of the courts to invalidate any law which is inconsistent with the Constitution, including the Charter of Rights and Freedoms. And so that's the invalidation of a constitutionally infringing law, and also the authority for the courts with given great discretion to provide remedies to individuals and groups whose rights have been infringed. So the ability to strike down unconstitutional laws and the ability to provide remedies such as damages and remedial orders to groups that have been affected by this, adversely affected. One of the things I would note here is that the Charter of Rights and Freedoms, it really has quite an interesting origin. It flows largely from United Nations documents. And the two documents which are most important are the UN Universal Declaration of Human Rights of 1948 and the 1966 Universal Covenant on Civil and Political Rights, both United Nations documents. And these are foundational documents for political and civil rights worldwide. And but the source of these in the international community, I think, is worthy of note. Canada considers itself a responsible member of the international community and seeks to abide by the norms of international law and good practices among countries. So, just to sum up very quickly, the Constitution of Canada today is not found in a single document. It is found in four primary sources that have to be read together to understand the constitutional arrangements for the country. The first one is the Constitution Act 1867, which established the country and which established its federal structure. What certain authority was given to the national government, certain authority was given to the provinces. Second, the Constitution Act 1982, and the most significant component of that is the Charter of Rights and Freedoms, to which I've referred. The third source is Aboriginal and treaty rights, which are now accepted as constitutional in nature and constitutionally protected, and are being developed further to some extent by the decisions of our courts, but in large measure by negotiations on a nation-to-nation basis between federal and provincial governments on one side and Indigenous groups on the other. And then this strange set of arrangements, it's a sort of obscure set of arrangements that we inherited from Britain as to the Westminster system of government. And the only thing I can say about it, because it's a large topic and it's a bit difficult to address because you can't find a document in which there's an authoritative statement of these things. It's drawn from a whole variety of sources. But the simplest thing I can say about it is it deals principally with the separation of powers. What is it that the executive can do? What is it that the legislature can do? And what is it that the judiciary can do? And of course, that's a very important component of constitutional law as well. So all of this is best understood in the historical perspective, and it has a bit of complexity, but taken all together, that is an overview of the Constitution of Canada. Thank you.
Thank you so much, Your Honor. That's very thoughtful and very informative presentation regarding the historical of Canadian constitutions. We now move to the last sessions. We'd like to invite the Right Honorable Chief Justice Richard Wagner, who will share his thought on the important issues, the rule of law and judicial independence. The floor is now open for you.
Thank you very much. Good afternoon, everybody. I'd like, first of all, to thank all the members of the Constitutional Court of Indonesia for bringing us together for this important conversation. It is an honor to be with colleagues from Indonesia, a country with a rich legal tradition and a commitment which we share to improve justice. I am pleased to offer a few reflections on a subject that lies at the foundation of every democracy, the rule of law and judicial independence. These principles are universal, but the challenges we face in safeguarding them are evolving, and no country is immune. Across the globe, we are witnessing new and troubling threats to the rule of law and judicial independence. A few months ago, the World Justice Project released its 2025 Rule of Law Index, and the statistics are worrying. For the 8th year in a row, the rule of law has declined in most countries, and this decline is growing faster. We see attempts to politicize the courts, erode public confidence in our justice system, and undermine judicial independence. Around the world, some leaders openly dismiss the authority of international law, while institutions that form the bedrock of our democracies come under sustained pressure. We have seen judges of the International Criminal Court, including a Canadian judge, subjected to economic sanctions for issuing rulings in cases involving alleged war crimes. These are not isolated developments. Together, they reflect a broader and troubling pattern of democratic backsliding. As you have heard from my colleagues' presentations, we are fortunate to rely on robust institutions in Canada. Our country ranks 13th out of 143 countries in the 2025 Rule of Law Index. Of course, we have some challenges, but our courts remain steadfast guardians of the rule of law, resilient in the face of new challenges, and unwavering in their commitment to upholding the rights and freedoms of all Canadians. This begins with the way judges are appointed. In Canada, the federal judicial appointment process is open, transparent, and non-partisan. Yes, the cabinet makes the final decision on who to appoint, but members of an independent advisory board submit the short list of qualified candidates. Judges hear cases and make decisions independent of undue influence. The principle of judicial independence assures Canadians that judges make decisions based on the facts and the law, nothing else. Judicial independence is not for the benefit of judges, but for the benefit of the public. I am proud of the work accomplished in Canada to preserve and strengthen the independence. In 2019, together with the Minister of Justice and Attorney General of Canada, I signed the agreement to strengthen the independence of the Supreme Court of Canada. This agreement reaffirms our shared commitment to an independent, accessible, and effective justice system for all Canadians. In 2022, as chair of the Canadian Judicial Council, I concluded 2 additional memorandum of understanding with the government. These agreements further consolidate judicial independence and clarify our respective roles and responsibilities, particularly in matters of judicial governance and training. As a symbol of the Canadian judiciary, the Supreme Court of Canada has also taken steps to highlight its independence. Our new heraldic emblems and flag are not simply ceremonial. They are expression of our enduring commitment to justice, impartiality, and the rule of law. But independence alone is not enough. Public confidence is the oxygen of the justice system. Transparency and accountability are essential to sustaining that confidence. The rule of law is not an abstract principle, and judges should not be faceless figures. We are human beings, and it is precisely our humanity that gives strength to our role. Since becoming Chief Justice of Canada in 2017, it has been a priority to connect with Canadians and reveal the human face of the court. For instance, our court, which is located in Ottawa, the capital of Canada, sat in Winnipeg in 2019. Sitting in another city represented a historic first. In 2022, we repeated the experience in Quebec City, and in 2027, we will be sitting in Halifax, Nova Scotia. These sittings are not only symbolic, they are opportunities to meet people where they are, to listen, and to explain not just what the court does, but why it matters. We have also invested in plain language communication. Since 2018, our court staff have produced the cases in brief for each decision. Cases in brief are a one-page summary of our judgments intended for the general public. They are posted on our website and social media at the same time that the judgment is released. We publish an annual year in review to highlight milestones and offer a window into the court's work. And each year, I hold a press conference to address broad questions about the court's role and the administration of justice, never commenting on pending matters or specific legal issues, but engaging openly on topics that affect the profession and the public. These initiatives share one purpose: to make justice real, to make it tangible, to make it accessible. When the public understands our process and our limits, they are more likely to trust our judgments, even when they disagree with the outcomes. In global terms, I like to say that Canada may not be an economic or a political superpower, but we are, without a doubt, a democratic superpower. Our constitutional system and judiciary have inspired both emerging and established democracies around the world. For example, the National Judicial Institute, which I have the privilege of chairing, is an internationally recognized leader in the design and delivery of judicial education. Its mission reflects a simple conviction we all share: that strong, well-educated judiciaries are essential to the rule of law, and that we strengthen our institutions when we learn from each other. This is why I am deeply grateful for our first judicial exchange. Indonesia's legal landscape is distinguished by its scale, diversity, and legal pluralism. While Canada's experience is different, we share common challenges: increasing caseloads, the need for modernization, the complexity of public communication in the digital age, and the pressing task of ensuring access to justice. None of us has the monopoly on solutions. Each of us has something to offer and something to learn. By working together, by strengthening our institutions, and by reaffirming our commitment to justice and independence, we contribute not only to our own countries, but to the global community we serve. Terima kasih. Thank you very much.
Thank you so much, Your Honor, for those clear and thought-provoking reflections, including how you take some initiative that probably can we adopt in Indonesia, but not sitting outside, but for the brief, in some cases in brief, and also engage with the media, and I believe that it can strengthen the public confidence to the Supreme Court of Canada. Now we are moved to the brief Q&A sessions. However, due to time limitations, we can only take 1 or 2 questions. And first, I would like to give opportunity to participants attending inside the room. Anyone? 3. Okay. Yep. Yeah, using glasses. Please make it short because we have a very limited time. And for those who attend this event through Zoom, you can just write the questions and then I will read it out. Please.
Excuse me. Thank you for the honor that I am given by the moderator that I'm standing here in front of the justices and chief justices of the Supreme Court of Canada. First of all, I want to ask 2 questions.
Could you tell your name and which university?
Excuse me. Let me introduce myself. My name is Cristiano Finuno Bramaditya. I am an intern here at the Constitutional Court of Republic of Indonesia. I am from Brawijaya University in Malang. Now, excuse me, the moderator, can I go to the questions?
Yeah. Just go direct to the questions.
My first question is the opinion of the justices and chief justices about the law. That I am a strong believer that the law are products of politics or a political product. What are the justices or chief justice opinion on that? Is the law a product of political decisions, or are they a product of cultural developments? The second, we are now in a industrial revolution 5.0, they say, and we are currently facing a lot of privacy problems in the world. We've seen a lot of privacy breaches by big tech companies like Palantir or companies that are giving governments the access to breach their citizen privacy. How can the constitutional law in Canada protect their citizens from that unconstitutional act, like the Constitution of Canada said in Section 8 or Section 7? That is my question. Thank you for the time.
Thank you. Thank you for the questions. There are 2 questions. One is about whether a law, which is the legislation, is a product of politics, and the other about the privacy law.
No? Yes? So I can deal with the first one and let one of my colleagues deal with the second one. For the first question, I think it's a law is usually the law represents the moral value of a society. So Parliament in some countries, well, in Canada that's for sure, will adopt the law. And usually we will look at the law as representing the common values, the common agreements among citizens. So legislation is a product of society, but society's values. And it belongs to the Parliament to adopt the law. And the courts, insofar as the Supreme Court of Canada is concerned, will simply interpret the law whenever a case is brought before the court. But it's up to Parliament and the local legislatures to adopt legislation. We do not create the law as such. But in the process of interpretation of the law, we could provide some evolution in the law, but it's always when the case comes to us. I give an example. If there is a challenge to the constitutionality of a legislation, as a result of our decision, that may bring an amendment to the law which will provide some kind of evolution. And some people will say, well, that's government by judges, whereas we simply accomplish our task to determine the legality of legislation. So I think to answer your question, I think that the law is more complex than simply a piece of paper or an order. It's the result of the notions accepted by the majority of society. And it's up to Parliament to adopt those legislations.
Your second question was with respect to the issue of privacy. And you're familiar with the Canadian Constitution because you quoted the right section, actually, Section 8, the right to privacy. And so that piece of the Canadian Charter of Rights and Freedoms, which Justice Rowe spoke to you about, is a preeminent document, and it actually controls the actions of state actors. And when I say that, we can speak of, for example, police authorities. And this court dealt very recently, in fact, with issues arising from Section 8 and access to information relating to subscribers of social media, et cetera, and what the requirements were in law to comply with the Charter of Rights in Section 8 in terms of the actions of police in accessing this information. It was determined by a majority of the court that prior judicial authorization would be required in order to access that type of information. And so there's certainly a lot of activity in this area as technology evolves, but the law can accompany that through these measures such as judicial authorizations. We can talk about a telewarrant. These are ways of dealing with prior authorization that are relatively easy in our modern world to obtain, as long as the grounds are there to obtain them. So that's the screen that the Charter of Rights provides.
Just very briefly, the question that the young man asked is a very important question because it brings to light the opposition of the democratic principle, which is that the majority rules and that from time to time the governmental institutions will make decisions which are made by those who were given an electoral mandate. And yet there are certain principles and values, as the Chief Justice indicated, which are so fundamental to our society that they are enshrined in constitutional instruments such that the democratic principle cannot be used to overwhelm them. There's a choice by the society of a more fundamental nature to elevate these above, if I can put it this way, day-to-day politics. And I commend to you the study of political and legal philosophy. My favorite is a bit hard to read, frankly. Hans Kelsen, who's the great Austrian legal philosopher. But he puts it, I think, most eloquently about the idea that the society conceives of itself in a certain way by reference to certain norms and values, which are then enshrined in constitutional instruments and will not be put aside or swept aside by the politics and the functioning of democratic institutions from time to time. So that it's the answer is democracy and the principles of constitutional law are consonant, but one is ultimately superior to the other, and that is the principles of constitutional law.
Well, I hope it's answered your questions. We have few questions raised from Zoom, from Adam Suharto from Faculty of Law Wijaya Kusuma University, Purwokerto. And he has a question for each of you, so it's specific. For the Right Honorable Chief Justice, how has Canada's experience been in balancing judicial restraint and judicial activism in strategic constitutional cases? Because in Indonesia, in academic atmosphere, judicial activism and judicial restraint is a hot topic here. And for Honorable Justice Rowe, how does the Supreme Court of Canada view and resolve conflict between freedom of expression and hate speech? It's also an issue in Indonesia, especially during the massive development of social media. And for Honorable Justice Moro, how does the Supreme Court of Canada ensure the consistency of judicial decisions across a generation of judges? There is a last question. Anyone can answer this. This is from one of our staff that has doing a PhD in Liverpool. So she's following this event from Liverpool, UK. Her name is Rima. He asks, Your Honor, how does the Supreme Court of Canada ensure the political rights of persons with disabilities, particularly their passive electoral rights, such as the right to stand for election and be elected for public office? So those the question, and then we will close all the questions.
All right, so let's start with the first one. Yes. Restraint or activism. I'm not comfortable with either term. I don't really accept those terms. It's a perception. I would say that the judges, and for sure at the Supreme Court of Canada level, we are doing our job. For certain people, doing our job would be a sign of activism. For others, would be a sign of restraint. I'll give you the example. When a legislation is challenged before the court on a constitutional basis, if the court comes to the conclusion that the legislation goes against one of the Charter of Rights provisions, like equality, and we quash the decision and we quash the legislation, some people will say, well, that's activism. That's government by judges. But if we say that, no, that legislation is legal, is in line with the Constitution, then nobody will say a word. Is that restraint? So you see, it depends on the way the vision, the way you look at a situation. I think that you will never be able to avoid that type of comments. But if we take and if we assume that everybody has a role to play, there's a separation of powers principle that governs our country, the judges will interpret the law, and Parliament and legislature will adopt the law. If we start by that concept, everything will be understood. But sometimes the courts have to intervene to make sure that legislation, a piece of legislation, is conformed to the Constitution. So to answer that question, I believe that it's a question of perception more than reality.
Do you have a word for right of disabilities?
Well, of course, we have, again, the Charter of Rights and Freedoms provides some provisions to make sure that every citizens of this country is treated equally. And so there were some challenges, and there will be other challenges throughout the years regarding certain situations which put the disabled people in a most vulnerable situation. And the courts will be there, and it has been there, to either validate legislation or quash legislation that would make those people more vulnerable and that could not benefit from the Charter of Rights.
I'll answer very briefly on this issue of consistency. You saw the pyramid earlier. This court is at the apex of the court system in Canada. And so a lot of care is taken to provide for consistency, because without it, there would be a state of confusion in the law in Canada. I mentioned that cases that are we attract and look for are cases where there is confusion in the law in the lower courts. So we take on those cases in order to resolve the legal confusion. And then once we have written on the subject, it would take quite an effort to overturn what we have written about the state of the law that creates consistency. Social mores change, society develops, and of course the law has to breathe. But we certainly value the consistency because it directs the lower courts in Canada.
The question about liberty of expression and hate speech is very instructive. It's very instructive. I'm going to speak at a somewhat elevated level, and then I'm going to bring it back down to a much more specific level. The thinking behind international human rights and how those are captured in constitutional arrangements among free countries was really deeply informed by the cataclysm of the Second World War. I mean, there was no single event, certainly in modern human history, which was so absolutely destructive, and from which those who survived and took on positions of leadership said, we must never allow this to happen again. And there were three great goals which were established and carried forward, notably through the United Nations and through countries of goodwill and freedom operating with one another. One was there must be freedom, personal freedom within each society. That points, of course, towards liberty of expression. There must never be the oppression of minorities and the persecution and, frankly, the extermination which occurred during the Second World War of minorities. And the third one, which is a little bit different, there must be an end to colonialism. That must end, and that was a very important in the post-war period. But there's a tension between these two goals. One is of liberty of expression, which is absolutely necessary for free societies, and the protection of vulnerable groups from persecution. And so the Canadian constitutional jurisprudence relating to hate speech has been directed towards a principled balancing of these, such that the greatest scope is given to liberty of expression right up to the point where that expression calls for persecution of an identifiable group. And the answer is, our society will never go back to what occurred in the cataclysm of the Second World War in terms of that kind of persecution. And that's where the line is drawn between liberty of expression and hate speech. And it goes back to fundamental values, as the Chief Justice said. So that's stated in somewhat general terms. There's always difficult boundary questions, but the answer is our society cannot tolerate a situation in which minorities and vulnerable groups are targeted for persecution, and to the extent that there is some limit on the freedom of expression, we accept that.
Well, thank you so much for you. Unfortunately, we have run out of time. Let's give a big round of applause for our distinguished speaker. So, ladies and gentlemen, we have come to the end of our program, Law Beyond Border, or LBB, Courts, Constitution, and the Rule of Law, the Canadian Experience. On behalf of the organizer, I would like to extend our deepest gratitude to the Right Honorable Chief Justice Richard Wagner, Honorable Justice Malcolm Rowe, and Honorable Justice Mary T. Moreau for sharing their perspective and experience with us today. I believe the reflection on constitutional adjudication, judicial independence, and role of courts in protecting the rule of law have been truly enriching. I also wish to thank to the organizer, our interpreter behind, Ms. Kiki, who assists all 500 participants through online, and Shirley also. Because of all these activities, this discussion have lively and meaningful. But since we have a special guest today, I would like also to invite His Excellency Jess Dutton, the Ambassador of Canada to Indonesia, to give some words. Please.
Selamat sore. Apa kabar? Great. Well, thank you very much. It's a great honor for me to be here. And it's a great honor as Canada's ambassador to Indonesia to have such eminent members of Canadian society with us today. Represented our justices from the Supreme Court of Canada, including, of course, our Chief Justice, and to able to have the engagements with all of you today, but also consultations with the Constitutional Court, I think is really, really important. And just to put it in context for all of you, the relationship between Canada and Indonesia is a very, very strong one. And it's a partnership. And this partnership is even more critical today in a more challenging geopolitical environment. We're partners in prosperity. We just signed a comprehensive economic partnership agreement, which will come into place and be ratified this year. We're partners on complex and important global issues facing our societies here in Indonesia, whether it be food security, energy security, development of human capital, and of course, economic development. Canada and Indonesia walk hand in hand. And so it's great to see this partnership expand to the judicial realm, to have the highest courts in our lands, to have the consultations, to compare notes and to share experiences, I think is really important in this ever-changing and complex world. But one thing that Canada and Indonesia have in common, and you know, we have different societies, different histories, but of course, as strong democracies, the rule of law is critical to our faith in our institutions. And to have an independent Supreme Court and Constitutional Court is critical to our faith in our institutions and our democracies. And so I think it's been a great experience to hear from our justices from Canada who have come a long way. And you know, it's winter in Canada right now. So in Ottawa, I think it was minus 20, which minus 25, in fact, I stand corrected. So, but it's been great to have them here in Jakarta, in Indonesia, for the past few days. And I really thank the Constitutional Court for making these important consultations happen, because it's really, really critical that our justices, members of the Constitutional Court, continue to learn and learn from each other. So thank you very much. Terima kasih.
Thank you so much, Your Excellency. We hope that our 2 days event will encourage a further dialogue between our courts and also our legal communities. So thank you once again for your participations. With that, I formally close today's program. Have a good afternoon and see you at another international event organized by the Constitutional Court. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you. May I kindly invite you all to join me giving a round of applause for one more time for the speakers and the moderator. Thank you very much. And ladies and gentlemen, before we conclude, allow me to note that today's public lecture also marked a continuation of the constructive dialogue initiated during the visit of the Constitutional Court of Republic of Indonesia to the Supreme Court of Canada in June 2024. We hope that this exchange of perspective will further strengthen mutual understanding and create sustained cooperation between our judicial institution in the years to come. With that, we formally conclude today's event. Thank you very much. Have a good day. Wassalamualaikum warahmatullahi wabarakatuh.
Apa sih?